state. I've got Mr. Yelsey, Mr. Hanson present for Mr. likewise is present. Mr. Hanson, you're telling me we're going forward without Ms. Liberty, without Mr. Benjamin, and without Mr. Hickman. Is that correct?
Yes.
So, in preparation for the 2 days of all pending motions, I was going to put on the record, I know that the defense wants me to take one of these out of order. I think they're probably correct about that. But let me just put on the record real quick, everything that I've read in preparation for the all pending motions that I gave you all day today and all day tomorrow. So I endeavored to try to read everything in the electronic file, all filings and any authority cited therein that took place since the mistrial was declared in Mr. Rubin's previous trial, which was July 22nd, 2023. So these are all the pleadings that I read that were filed by the defense. I did read also all the orders that Judge Murphy entered, but I do realize some of these may be due, but in the abundance of caution, so I would be prepared. I nevertheless did read all of them. As we go through them, I'm sure you all will let me know if it's something that I need to resolve or it's something that's already been resolved. The defense, and I'll do these in chronological. I read the defense motion to compel Brady material that was electronically filed August 23rd, 2023. I read the defense motion to compel discovery that was electronically filed August 31st, 2023. I read the defense motion for discovery of prosecutorial investigations and prospective jurors electronically filed September 6, 2023. Defense motion for disclosure of penalty phase evidence electronically filed September 13th, 2023. The defense's motion in limine regarding phone, social media, and business records electronically filed September 21st, 2023. Defendant Janelle Evans' motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health phenomena electronically filed October 4th, 2023. Defense motion to exclude testimony of defendant's alleged gang affiliation electronically filed October 4th, 2023. Defendant Janelle Evans' response to state's motion to quash subpoenas and/or for protective orders, and for an order to compel witnesses to be deposed and to attend hearings, electronically filed October 4th, 2023. Defendant Janelle Evans' motion to compel discovery, electronically filed October 4th, 2023. Defendant Janelle Evans' motion in limine to exclude certain testimony of Detective Mark Ray along with CellHawk, call data, record, mapping, Google Maps, electronically filed October 5th, 2023. Defendant Janelle Evans' motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health phenomena, electronically filed October 5th, 2023. Motion to exclude testimony of expert witness and memorandum of law, electronically filed October 6, 2023. Response to state's motion to quash a memorandum of law, electronically filed October 9th, 2023. Memorandum Ray, ASA, Christine Bradley testified, electronically filed October 9th, 2023. Defendant's second motion for redeposition of Detective Mark Moretti, electronically filed October 29th, 2023. Defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights.
Judge, that can be struck because we filed the third one and that incorporated the second. And then we have a ruling on the third one.
Okay, well, hold on. Let me get all of them,
All right.
and then we'll go one at a time. That's why I gave you 2 days. This one is defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. That one was filed November 1st, 2023. Defendant Janelle Evans' motion to exclude, electronically filed November 2nd, 2023. Defendant Janelle Evans' motion to strike the state of Florida supplemental discovery, electronically filed December 14th, 2023. Defendant Janelle Evans' reply to the state of Florida's response to defendant's motion to strike the state of Florida supplemental discovery list, electronically filed December 17th, 2023. Objection to business record certification and/or motion in limine, electronically filed December 18th, 2023. Defendant's third motion to compel forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams, electronically filed April 15th, 2022. Defendant's request for status hearing, electronically filed April 15th, 2024. Defendant's motion to set aside stay and/or modify stay to allow discovery to proceed, electronically filed April 25th, 2023. Motion to compel discovery, electronically filed May 13th, 2024. Defendant Janelle Demon's motion in limine number 2 to exclude irrelevant and immaterial YouTube videos of 1090J, electronically filed May 14th, 2024. Defendant's motion to strike the state of Florida's motion for rehearing dated May 14th, 2024. That is electronically filed May 14th. And then a defense motion for hearing to determine potential conflict, electronically filed December 27th, 2023. From the state attorney's office, I read the following. State's motion to refer to potential and seated jurors by number instead of name, electronically filed October 6, 2023. State's motion to allow former testimony of state witness, filed October 6, 2023. State's motion to strike State Attorney Harold Pryor, Assistant State Attorney Regina Falk, and Assistant State Attorney Christopher Killoran from Defendant Demon's supplemental witness list for trial, filed on September 29, 2023. This pleading was electronically filed October 10, 2023. State's motion to strike Assistant State Attorney Christine Bradley from Defendant Demon's supplemental witness list for trial, filed on September 29, 2023. That's electronically filed October 10, 2023. State's motion for admissibility of consciousness of guilt evidence and request for ruling prior to jury being sworn, filed October 20th, 2023. State's motion to withdraw State's motion to strike ASA Christine Bradley from Defendant Demon's supplemental witness list for trial, filed on September 29th, 2023. That is electronically filed on October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demon's supplemental witness list for trial, filed on September 29th, 2023. That is electronically filed October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demon's supplemental witness list for trial, filed on September 23rd, 2023. This is not a duplicate, this is an additional document, also filed on October 25th, 2023. State's board memorandum of law, electronically filed October 30th, 2023. State's response to defendant's motion to redepose Detective Mark Moretti, electronically filed October 30th, 2023. State's motion to strike all jurors for cause with significant knowledge of the previous trial, electronically filed October 30th, 2023. State's motion for protective order and quash subpoena, electronically filed October 31st, 2023. State's motion limiting to prohibit defendant from improperly pretrialing his cause or making misstatements of law during board-out, electronically filed November 1st, 2023. State's response to defendant Janelle Demon's motion to exclude, electronically filed November 6th, 2023. State's response to defendant's motion eliminating a phone, social media, and business records, electronically filed November 6, 2023. State's response to defendant's motion to exclude testimony of defendant's alleged gang affiliations, electronically filed November 6, 2023. State's omnibus memorandum of law in opposition to defendant's motion to suppress evidence, electronically filed November 6, 2023. State's memorandum of law raised striking jury panel due to defense misstatement of the law, electronically filed November the 8th, 2023. State's motion to strike the defendant's second motion to dismiss for government prosecutorial misconduct in violation of the defendant's due process rights, electronically filed November 28th, 2023. State's motion to strike the defendant's unilateral setting of depositions and the state's proposed deposition and motion schedule, electronically filed December 16th, 2023. State's response to defendant's motion to strike the state of Florida's supplemental discovery, electronically filed December 16th, 2023. State's motion to limit to exclude testimony of Michelle Boutros and Christine Bradley, electronically filed December 17th, 2023. State's motion to strike the defendant's sworn motion to dismiss, electronically filed January 12th, 2024. State's response to defendant's objection to business record certification and or motion in limine, electronically filed January 23rd, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 15th, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 17th, 2024. State's response to defendant's motion titled Third Motion to Compel Forensic Images of the Cell Phone, electronically filed May 20th, 2024. I did also today do the state's motion to strike defendant's notice of hearing, electronically filed January 2nd, 2025, as well as the state's response to defendant's motion to compel discovery, filed on May 13th, 2024, electronically filed January 2nd, 2025. As far as previous orders that Judge Murphy entered, I read all of the following. Order denying defendant's motion for redeposition of Detective Mark Moretti, entered August 7th, 2023. Order on motion to remove electronic monitor, entered August 25th, 2023. Order denying defendant's motion to set bond, entered September 22nd, 2023. Order denying defendant's motion to recuse State Attorney's Office of the 17th Judicial Circuit in and for Broward County, Florida, entered October 12th, 2023. Order granting defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley, entered October 12th, 2023. Order granting State Attorney's motion to quash subpoenas and/or for protective orders, entered October 12th, 2023. Order denying defendant's motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights, entered October 20th, 2023. Order on state's motion for inquiry of all pre-qualified jurors and motion for relief, entered October 26, 2023. Order granting in part and denying in part defendant's second motion for redeposition of Detective Mark Moretti, entered November 7, 2023. Order denying defendant's motion to declare section 921.141 subsection 6 subsection N of the Florida statutes unconstitutional, entered November 14, 2023. Order on deposition of state witnesses, entered on November 15, 2023. Order granting the state's renewed motion to reset the trial commencement date, entered November 15, 2023. Order denying defendant's motion in limine Gray agreement between Devens and Williams as to sharing of any money, entered November 17, 2023. Order Ray's second deposition of Detective Danny Polo, entered November 21st, 2023. Omnibus order on defendant's motion to suppress numbered 1 through 13, entered December the 20th, 2023. Order on the state's motion for rehearing / reconsideration, entered January 11th, 2024. Order on defendant's motion to dismiss for violation of due process and double jeopardy and/or motion to recuse entire state attorney's office of the 17th Judicial Circuit, entered January 19th, 2024. Order on state's motion for clarification, entered January 24th, 2024. Order denying the state's motion for reconsideration, entered January 25th, 2024. Order granting defendant's motion in limine Ray promotional video, entered January 25th, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed, entered May 2nd, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed. That's what people do. Order denying the state's motion for rehearing and reconsideration of the court's order modifying the stay to allow discovery to proceed, issued on May 2nd, 2024. And that's issued on July 16th, 2024, not pro tunc to May 16th, 2024. So, that's everything that I looked at, as well as any authority cited therein, statutes, case law, or otherwise. You don't have to repeat yourselves, but you certainly can if you would like. I have the balance of all day today. I take a lunch break between 12:30 and 1:45. I can likewise give you the entire day tomorrow. I won't limit either side to present whatever evidence, witnesses, or testimony they would like to present. Defense, I'm going to start with you, and I also did read Rutledge versus State, which is 157 third 830, regarding the defense motion for hearing to determine potential conflict. So, whenever you're ready, you may proceed.
Thank you, Your Honor. Rutledge and other cases, federal cases, because State Florida really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demings, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not that has been waived up until that time, I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty, and they happened to fall before the end of Mr. Demon's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Devins, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demons' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demons' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Ms. Liberty is in fact facing charges formally. And if that occurs, then A, she can't try the case. I'm not sure the rest of the defense team can try the case. And don't know, and a prejudice to Mr. Demons would be monumental that at this late stage you have to get a whole new defense team. So we need these questions answered. It's not just as simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state, wait for this matter to be over? We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demons, or a separate trial? Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Demons in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demons on the other side of the glass partition by phone. Have they been tapped? Have they been listened to? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, we can't go forward as a defense team on any of these motions until we talk to Mr. Demons and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Ms. Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the court, I think all members of our defense team need to call up the Florida bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case. regardless of Mr. Demings' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Demings has a lot of thinking to do. Hopefully the court will give us a hearing and some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decisions.
Rutledge said, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you said you want to answer? Because I didn't find any authority in that. I don't even know how I would do that.
Well,
Do you have any authority? I understand you're saying, that's the judge, this is what we'd like. I read what Rutledge says, that's what I'm doing right now. But you want to know about investigations, you want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires me and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. What do you, I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question. Is she under investigation? And the answer is yes. So the only other question that Rutledge requires is that Mr. Demings has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well,
Right.
then I will file another motion for prosecutorial misconduct and ask for a hearing on that. Subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only
That's
conflict.
what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well,
criminal procedure tells me to do. I don't make up things on my own.
then I ask the court, let's go one step at a time. Right now, Mr. Demings now has been informed that his liberty is under investigation. And let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demings needs to know these before, quite candidly, he can make that choice. He can say right now that he wants Miss Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Miss Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today?
I don't
And
think we can.
when would you like me to reset?
I do not know how long it will take. Miss Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight, including Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30, but I do think it takes some time for us to talk to Mr. Demings. She certainly needs to talk to Mr. Demings. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time, quite candidly. And we need to develop, if I may,
Yes, sir.
we need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the taint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13th, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabanis. And I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13th, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called taint team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is, since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well,
Has
that's all I
anyone said
have.
anything that this has anything to do with Mr. Demings?
I can't answer that without seeing the search warrant.
We're not here to make work. Does this have to do with Mr. Demings?
It doesn't.
Okay.
So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Demings make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. You can't give anything over until it's officially completed.
With all due respect, but this is the high due process part when the state's seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right.
It does not have to do with the homicide case.
Well, in any case, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll speak with my office and you can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? The defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery for her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Demings has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over, that's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we need to file any sort of motion to prevent the search warrant from being over.
I mean, I just can't imagine any legal grounds that would not happen in this particular case. It's a death penalty.
I understand
It's a
that.
death penalty.
And then I'm asking for at least a day or two. At
You
minimum.
decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't, under the Florida bar rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Devens. And state you will have the balance of today to discuss some reason why you can't just turn over this affidavit at search warrant.
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so. But maybe it's something so de minimis that Mr. Devens is going to say, that's fine. If there's any conflict, I'll waive it, and, let's get to work. Or if not, I guess he's going to have to go find 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So how about tomorrow at 9:30?
We'll be here.
State tomorrow at 9:30?
That's fine, Judge.
And it can't, again, I'm not picking on you, but the answer can't be, my office told me X, Y, Z. Someone better be standing here with some authority that tells me they can't do it. Okay?
Judge, one other thing,
Yes, sir.
you mentioned about the trial schedule, but we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the 4th DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we would get a ruling. The problem is the stay that was issued by your previous judge. We cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions?
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there is a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, couldn't I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, for example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just,
Do you have any objection to doing that?
we're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of a waste of time to do the motion.
No. A waste of time is reserving 2 entire court days for doing nothing. That's a waste of time. So do you have any objection to going forward and me hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I have not looked at that motion.
Okay, so why don't we do it this way, all right? he's gonna remain on the docket tomorrow. I have a few other matters on both FX and FT, so let's call it 9:30 tomorrow. And defense, you can come in and tell me if you had a chance to talk to your client, because if he's gonna waive any potential conflict, then I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're gonna tell me what you wanna do, state, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the, motion to strike the notice, because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in Odyssey. So we have identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for some of these.
you're gonna go to trial in September. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's gonna go to trial in September. So I'm gonna do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're gonna do. So,
Assuming we're still on the case. And that's a big assumption at this moment.
And just, we're still asking for proper notice of what we're actually
I'll take the blame for that. All pending motions, that's why I put that down to the end of the month. All pending motions. They're asking for I believe, they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matter, cell phone mapping. There's a whole bunch of things that.
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title, she's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for what you did?
Yeah.
Okay, so the FX and FT are both going to otherwise be recessed until tomorrow, which is.
Excuse me.
Yes, sir.
I've been told that Mr. Devens has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent him on that.
Tomorrow is Tuesday, January the 7th. FX and FT will be in recess until then at 8:45 a.m. I hope you all have a good rest of your morning. All right, Mr. Court Reporter, that is it.
Yes. The same right now? Oh, okay, 2 minutes.
Here.
No, the jail.
Yeah. Thank you. May we be excused?
Yeah, we're good. Have a good morning. Use your time wisely.
Yes, sir.
Are you ready for me to go on the record?
Yes.
Okay.
Yes, sir.
Yeah, as soon as I get Mr. Court. State, you ready?
Yes, sir.
Okay. We're waiting for the court reporter, we didn't start yet. Ms. Collins, we're all insured, that's your case.
Yes, Judge.
That's
Set
February
the trial February 19th.
19th.
Yes.
Just so happens, okay. All right. Mike, take your time, so when you're ready. Good? Okay, let me go back on the record. This is State versus Jamel Demons, 19-1872 CF10A. I've got Ms. Bucklew, Ms. Collins, Mr. Griffiths present for the state. I've got Ms. Liberty, Mr. Adelstein, Mr. Aronson, Mr. Benjamin, present from Mr. Demons, who likewise is present. We're not waiting for Mr. Patanza.
We are not waiting for this presence.
Okay. Okay, so this is just a continuation of yesterday. I did get, and I read, as well as the authority cited therein, the state's motion for rehearing and reconsideration of the defendant's or tenant's motion to compel disclosure of the Apple search warrant related to attorney Raven Liberty. I don't know that I actually conducted a formal hearing. I just asked the state to turn over a copy of the search warrant and affidavit. Ms. Collins, let me ask you this. I read your authority. Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Well, can you explain that to me? Because if I sign a search warrant for someone's home, and BSO goes to their home and executes the search warrant, and they're there, they give them a copy of the search warrant.
Correct. But in
Upon
this
its
case, it's
execution.
Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
Yeah, that's correct, Judge. Yes.
That's your position?
Yes, Judge.
Okay. Okay, well, over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today, so you can litigate that as you see fit, but I certainly think she's entitled to a copy of the search warrant. Probably that's it at this point. So, defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is I need to give you a date very soon in the future, a date in February, which is what we're looking at. And at that point in time, you're going to have to come back in here and tell me, and I'm going to have a discussion with Mr. Demons. I'm going to start that discussion this morning. So when you're saying he's the captain of the ship, this is his decision, but he's going to have to tell me if he wants Ms. Liberty to continue to be his lawyer or not. He's going to have to tell me if he wants all of you to continue to be his lawyers or not, or he's going to have to tell me that he's going to seek other counsel. But I think that needs to happen sooner rather than later.
We concur with that issue. I'm confused, and I apologize to the court. Is the court entertaining this motion for reconsideration and not?
There was no motion or ruling. I think she's entitled to it. I think, listen, Mr. Demons is entitled to heightened due process. The state
Yes.
is seeking the death penalty. It is very clear that one of his lawyers is under investigation right now.
Okay.
He is entitled to have as much information as I have the ability to give him before he has to make a decision. Is there a conflict of interest? Does he want to waive that conflict of interest and continue with that lawyer as part of his representation? Or does he not? Does he want the lawyer to withdraw? And again, the Florida Supreme Court has been very clear on this. He's the captain of the ship. He
Absolutely.
makes this decision. So if there was, again, I'll repeat what I said, I think to Mr. Aronson yesterday, if you all had some other authority that says I have some additional power to assist in the fact finding here, I would hear what the state has to say about it, but I would probably be inclined to do that. But my inherent authority or citing the U.S. Constitution, although I very strongly believe in the U.S. Constitution, this is I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Demons wants to do. This is completely 100% a decision between himself and his lawyers. I don't have anything to do
We're
with it.
not disputing that.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move this trial date. His trial is going forward in September. So if these motions are heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the most ideal way to do things, but that's what ends up happening, that's what ends up happening. But the one thing I can tell you is not gonna happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning?
Well, a couple things. Since the state filed a motion for rehearing, there are misstatements in their motion that need to be corrected. Since we received this early this morning and saw it for the first time, we did not file any written plea of response. And if I may, just go through the corrections that we saw. It's on number 1, it says, the search warrant was issued in December of 2024. It was 23, not 24, a year earlier.
We agree with that, but that way up.
In paragraph number 2, they said that the state disclosed an ongoing investigation to Miss Liberty. That is absolutely untrue. We learned of it through Apple. They confirmed it yesterday for the first time, over a year after the search warrant was executed. Paragraph number 5 indicates that this investigation is separate and apart from the defendant's current case. It conflicts with paragraph 11 that implies that this investigation is related to the tampering case of Mr. Demons. Is it unrelated or is it related? I think the court needs to know that, because if it's related, I believe, and we will file a written response under discovery, he's entitled to that information, anything that leads to relevant and important information. And I'm not asking the court to rule on it at this point, but I want the court to know that if it's related to his present charges under 3.220, we're entitled to that information. They make a statement that regardless of what Mr. Demons wants and is willing to waive the conflict, they believe that Ms. Raven must get off the case, regardless of that. That's their assertion. They have to prove it. And I want to put the court, the state on notice that they must prove. They can't merely allege that the conflict is so extent that even if this young man wants to waive it, they're going to come in here and say she must get off the case. That's what they say in this plea in paragraph number 11. That's a question for the court to determine, and they have to present evidence of that fact. We are still under the same impression that we don't have enough information. Pursuant to Your Honor's request, Mr. Aronson and I spoke to Mr. Demons. I call him Melly if the court will allow me.
I'd actually prefer that you use.
Mr. Demons?
Yeah.
Fair enough.
Thank you.
Mr. Demons, we discussed the potential of that. And if the court accepts my representation, or the court can inquire from him, he informed us that he doesn't have enough information to make that decision.
You're talking to me about privileged communication.
Well,
I'm going to talk to Mr. Demons at the conclusion of the hearing this morning, everything that I'm allowed to talk to him about. I want to hear about anything that you all talk about.
I was just willing to profit the state of that fact. And we would, of course, ask the court to deny their motion for rehearing and rule consistently with what you ruled yesterday, that they not only have to produce the search warrant, but the affidavit.
Well, do you want to respond to any of the case law they cited about ongoing investigations? That would relate to the affidavit.
Well, it relates, if it's related to his present charges under Rule 3.220, they must turn it over. So let them come in here and make a representation that it is either unrelated, totally different, or if it's in fact related, he has a right to see that information. And 3.220 is clear on that. Anything that could lead to relevant information must be disclosed. Judge, there is one other matter that we need to go sidebar on.
Okay, well, hold that, pause on that till the end. State, is there anything else that you want to tell me today? The only thing I'm going to do is talk to Mr. Demons about the front end of this colloquy, if you will, and then give you a future date, which I'm looking at is February 18th. That's the day before my next trial starts, after the trial that's starting tomorrow. And on Tuesday, February the 18th, what I'm also going to ask each side to do is, if there's any motion pending that you think I can hear that is not interfered with by the pending matters that are up on appeal to 4th DCA, state if you have anything that you want me to hear on February 18th, just file a notice of hearing and identify the motion you want me to hear. Defense, if there's anything else you want me to hear on February the 18th, just file a notice of hearing and identify what it is you want me to hear. I anticipate the murder trial that I'm commencing tomorrow will be done by then. It may not be, but I'm hoping that it is. And if it is, then I'll give you the whole day on February the 18th to address this issue regarding his representation. And if it turns out we can go forward and hear some of these pending matters, then I'll be happy to do that too.
Judge, I can just ask, I know you said file a notice of hearing, if we could have a deadline like by February 1st, so we don't end up in the same position we did this time where it was filed, pre-business
Well,
before.
Let's see, we're talking about February 18th. So how about the end of business on February the 7th? How about that?
That's fine, Judge.
All right, so that goes for both sides. If there's anything you want me to hear on February the 18th, just file a notice of hearing, identify exactly what it is that you want me to hear. And I'm gonna see him February the 18th at 9:30 a.m. Again, we'll call it all pending motions. Maybe we'll be able to work all day and maybe we'll be able to do nothing. I guess that's really gonna be up to you all. State, is there any other requests that you have this morning?
Yes, Judge, as to the search warrant itself that Your Honor is going to compel us to provide, I'd ask that we have until February 1st, just so we have time to pursue the appellate remedies in the meantime, and then I'd also ask that it provide to Your Honor in camera first, because it's the state's position that there are, even in the search warrant itself, certain things that make reference to other targets of the investigation, which are confidential, privileged, and would jeopardize the investigation. So we would ask that Your Honor review that in camera, if any necessary redactions have to be made, and then it can be provided to defense.
We would object to that procedure, and they've had over a year to produce these documents, so it's no surprise. We would ask that to be given to us by the end of tomorrow.
Okay, so listen, over the defense objection, state, this is what I'll do. I'm ordering you to turn over a copy of the search warrant. I need you to get that to me. A week from today, that's January 14th. End of the day, January the 14th, that comes to me,
Yes, Judge.
and then I'll review it, and then I'll distribute it as I see fit. I can't imagine there's anything in there I'm gonna redact. I mean, it doesn't matter, the state's free to investigate whoever they want for anything they want. To do this in the midst of a capital case, state, I realize some things are gonna happen that you might not find ideal, but that is of your doing because you've chosen to do this in the middle of a capital case. So Mr. Demon's heightened due process rights will take precedent over every other matter in this case, obviously. So that's just the way it's gonna have to be. But I'll grant your request over the defense objection, at least as to that. Ms. Wilcox can give you a blank order. You can fill it out this morning. I know it's over the defendant's objection, but show them the order. And I'll be happy to sign it. The search warrant comes to me within 1 week.
Yes,
And
Judge.
then I will review it in camera and then I will distribute it accordingly as I see fit. State, anything else you want me to do this morning?
The Judge.
Defense, besides your matter that you want to talk to me about, sidebar, anything
Yes,
else you want
since
me to
you're
do this
going
morning?
to, in camera, review the search warrant, we would ask that the state submit the affidavit.
Well, the case law seems pretty clear that you're not entitled to that. But if you have some competing authority, I'm happy to look.
Yes, sir.
Your Honor, on another note, I was a little confused yesterday as to whether or not you have lifted the stay as far as discovery and we can and start discovery again on everything, or are we still under that stay order? Just asking for
I asked both sides if you wanted to do that. I thought you both told me that you did want to do that, that you wanted to do the things that you can do.
I want to do everything,
I agree with you.
but,
Time is short, but,
but the state is the one that asked for the stay.
well, Steve, what do you want me to do?
Judge, we need to speak with the Attorney General's office, because we have that stay for a reason with certain things, but we have plenty to do
outside of that.
outside of that first, so. we
Okay,
have
well, why don't we do the things that we all agree we can do? So the answer to Mr. Anson's question is yes, without objection from either side, the stay is lifted to the extent that we can litigate any matter that's not currently before
Well,
the
no,
court.
we are objecting to that, Judge.
That was already done by Judge Murphy.
Right, that's already been
Judge
done.
Murphy already lifted the stay.
He modified it,
Right, he
so that we
modified
could
it.
do ongoing discovery
okay.
as to things that were not up on appeal.
Okay. Again, if one side notices something for February 18th and the other side thinks that that is included in the matters that cannot be handled because it's currently at the Fourth District Court of Appeals, I'm sure you will file a written response and let me know that. And I guess I'll have to make a decision whether I agree with you or whether I don't. Defense, besides the matter that you want to talk to me about, anything else?
Judge, the only thing I would like to have you possibly consider is that you had said you were prepared to ask Mr. Deming some questions right now. I'm a little concerned that with the lack of information that exists in this case, for him to even opine on where to go right now, based on what? The paragraph in their motion that says that he has to make a decision now because we told him there's a conflict.
I'm not going to ask him any questions. I'm just going to explain to him the choices that he's made. No different than a defendant deciding to testify or not testify at a trial. I'm not going to ask him any questions. I'm telling him what's coming. Because at some point, he is going to have to tell me what he wants to do.
And of course, we're gonna object at this point, and until the time that he's fully informed as to what there is that may be a conflict, he is in no position to answer, to make an opinion as to
I'm
whether,
not asking his opinion. You're objecting to me talking to your client about his rights?
it depends on what you say, Judge, but I am prefacing what your comments are because I was under the impression that you were gonna inquire with him as to whether or not that he finds there's a conflict.
No, I'm not.
Okay, great.
I'm not. Okay, again, so the record is crystal clear on this. I'm following this procedure pursuant to a case called Figueroa, Figueroa hyphen Sanabria, Sanabria versus State. It's a Florida Supreme Court case from 2023. It's found at 366 Southern 3rd, 1035. And this was a death penalty case as well. I'll quote what the Florida Supreme Court quotes. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. All competent defendants have the right to control their own destinies. He's entitled to his constitutional right of assistance of counsel, and there's nothing that makes him relinquish this right. So all I'm going to do this morning is explain to Mr. Demons that at some point this is going to be his choice. I'm sure his lawyers will give him the best advice, but this is going to be his decision. And he may not agree with your advice at some point, just like a defendant may decide to testify or not testify and not follow a lawyer's advice. But I take this decision to be the same way. It's a fundamental decision. This is a client decision. This isn't a lawyer decision. So, Mr. Demons, raise your right hand for me. You don't have to stand. You're okay. You can sit. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name.
Chanel Maurice Jim.
How old are you?
25.
How far did you go in school?
I graduated, well, I got my GED.
You read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
How are you feeling this morning?
Confused.
I understand. I'm a little confused myself. Your head is clear? You're not hearing voices. You
No.
hear your lawyers. You're talking to your lawyers. You understand what's going on this morning?
Yeah.
Okay. All right, so Mr. Devens, here's the deal. You're, just like any other defendant, you're entitled to have a conflict-free lawyer or lawyers representing you. Okay, a lawyer that has your best interest in mind, to the exclusion of anything else. You with me so far?
Yes.
Okay. The state has told you that one of your lawyers is currently under investigation. For what? I have no idea. But there's some ongoing criminal investigation. Okay, you with me so far? Okay. So this, what your lawyers correctly pointed out yesterday, raises immediately what we call a conflict of interest. In other words, maybe at some point during this litigation or some point during the trial, my lawyer's not going to do what's the best thing for me. My lawyer's going to do what's the best thing for my lawyer. And your two interests are separate. You understand that?
Yes, sir.
Okay. So, once your lawyers have had the opportunity to investigate all this, to get you all the information they can possibly get, so they can talk to you about all this, at some point, you're going to have to make a decision about who you want your lawyers to be going forward. You with me on that?
Yes.
Okay. Even if there is a conflict, you can waive the conflict if you want and say, Judge, I understand there's a conflict, but that's okay. I like these lawyers. They're doing a great job for me. They did a great job for me in the past, and I don't want to change, lawyers this late in the game. You understand that?
Yeah.
Or you could likewise say the opposite and say, Judge, I don't feel comfortable with this. I think there's a conflict. I don't think Miss Liberty should be my lawyer anymore. I don't think any of my lawyers should be my lawyer anymore. And I want to go get some new lawyers. And if you want to hire your own lawyers, you can go out there and hire anyone you want. And if you want me to appoint lawyers to represent you, you would have to file an application with the clerk's office. And if they find that you're financially qualified, I could appoint lawyers to represent you. You understand that?
Yeah.
The whole point I'm trying to make with you today, sir, is that this is going to be your decision. Your decision. Your lawyers will give you their best advice, and you have some excellent lawyers, okay, about what they think you should do. But at the end of the day, you can follow their advice, or you don't have to follow their advice. It's your decision. Do you understand that?
Yeah.
Do you have any questions for me about anything that I've said so far?
Can we have a moment, John?
Sure. No questions? All right. So, Mr. Evans, I'm pressing pause on the conversation at this point. We're going to have the second half of this conversation at some point in the future. I hope it's sooner in the future rather than later, because the last point I want to make sure, and I'm giving you and your family and your lawyers as much notice of this as I can, your case is set for trial September the 10th, and that's not that far away. Do you understand that? Okay. Your case is going to go to trial on September the 10th. So if you change lawyers, you're going to get a group of lawyers in place that are going to have like 7 months to prepare a capital case, okay? So the longer it takes to make this decision.
I'm going to object to what the court has just said. What you're telling him is right now that he is basically having to stay with us as his attorney, because if not, then he'll get another set of lawyers that will not be prepared, and they will only have 8 months to do what has taken years to do, and therefore you're pushing him into the corner that he has to stay with us. I don't think that's fair what the court has said.
Over your objection, sir. That's not what I'm saying at all. I want to make sure that you understand that time is of the essence. Do you understand that?
Yes, sir.
Okay. So I'm going to put them back on the docket February the 18th at 9:30 a.m. This issue with the warrant will be resolved at this point, and whatever's going to be distributed to the parties will have long since been distributed to the parties. You all can file whatever additional motions you think are appropriate. If there's any motion that the state wants me to hear, we're going to do that in a notice of hearing. That's by the close of business on Friday, February the 7th. Defense, if there's any motion that you want me to hear, you're going to do that in a written notice of hearing by Friday, February the 7th. If I don't have something noticed in writing by Friday, February the 7th at the close of business, I will not be hearing it on Tuesday, February the 18th. Mr. Demons' case remains set for trial September the 10th at 9 o'clock. State, anything else that I can do for you this morning?
No, Judge.
Defense, with the exception of your,
Yes.
all right, is the state coming up here too?
Yes.
Okay. Mike, this is not on the record. Dan, I think there's a microphone here. That needs to go. Okay, so I'm going to see Mr. Livingston on February the 18th. If you need to get in front of me sooner, just contact my office, although I am starting another first-degree murder trial tomorrow. But that trial may end earlier than I suspect. I'll just play that one by ear. Ms. Wilcox, FT, that concludes FTs for today. That concludes FX until 3:30? Yeah. Okay. So then the division FX, I would like to be in recess until 3:30 this afternoon. Hope y'all have a nice one. All right, Mr. Court.
3:30 is the hearing?
Yeah.
All right, y'all. Looks like that's the end. Hey, I did want to let y'all know tomorrow I plan to start watching the Karen Reed trial tomorrow on the Morbid Law channel. I'm gonna drop the link here if y'all are interested. I have never seen the Karen Reed trial, but I want to see it. So we're gonna be watching that tomorrow. Let me grab the link real quick. It's about a year long trial, so it's gonna take a while. Not a year, a month. I'm gonna drop this in the dropping the link in the chat if y'all want to watch Karen Reed starting tomorrow morning. And I think closer to this trial, we'll go ahead and rewatch the Melly trial as well, the previous trial. But we can do that maybe starting in August, since this is going to be in September. So other than that, y'all, thank you for being here today. I'm going to go ahead and end the stream now. Appreciate y'all. Hit the like, please.